The case management alert arrived at 2:17 a.m. on a Tuesday, flagging discrepancies in my client retention metrics that shouldn't have existed. I'm Elias Forrester, 42, managing associate at our Delaware corporate law practice, specializing in mergers and acquisitions. 20 years of building client relationships, and suddenly the system claimed I'd lost 3 major accounts last quarter, accounts I'd personally serviced just days before. The notification glowed on my phone screen as I sat in my home office, reviewing discovery documents for the Morrison acquisition. Client retention reports weren't typically generated automatically. Someone had to request them. At 2 a.m, that someone wasn't me. I pulled up the firm's client database on my laptop. The Morrison Group showed active status. Sterling Industries remained under my management. Blackstone Holdings displayed my name as primary counsel. Yet according to the retention report, all 3 had terminated our services between September and November. The timestamps made no sense. The Morrison termination allegedly occurred on October 15th, the same day I'd negotiated their subsidiary purchase agreement. Sterling's supposed departure was dated October 22nd, when I'd been in their boardroom finalizing their IPO documentation. I scrolled through the billing records. Every invoice showed payments current, no outstanding balances, no client complaints in the system. The contradiction felt deliberate. My phone buzzed with another alert. This time, a billing discrepancy notification. The system flagged unusual access patterns to my client files over the past 6 weeks. Someone had been reviewing my case loads during off hours. The access log showed activity between midnight and 4 a.m., when the building's keycard system recorded no entry under my credentials. I checked the user authentication trail. The logins traced back to my account, but the IP addresses originated from the firm's training department. That made no sense. Training staff had no business accessing active client files, especially not mine. The Morrison file showed 17 unauthorized views since October 1st. Sterling Industries had been accessed 23 times. Each intrusion lasted exactly 47 minutes, long enough to review case details, billing structures, and client communication logs. I pulled up the partnership meeting minutes from last month. The board had discussed associate performance metrics and client retention rates. My name appeared in the discussion notes, specifically regarding my declining client satisfaction scores and recent account losses. Information that contradicted everything in my direct client communications. The training director, Colton Blackstone, had presented the retention analysis to the partners. His report recommended immediate intervention for associates showing performance deterioration. The document cited specific client departures that I knew hadn't occurred. My hands tightened around the phone. Someone was systematically misrepresenting my client relationships to the partnership. The question wasn't whether this was intentional. The precision of the data manipulation made that clear. The question was why. I opened my email and found 3 messages from clients, all sent within the past week. Morrison's CEO thanked me for the exceptional work on their acquisition. Sterling's general counsel praised my continued dedication to their IPO process. Blackstone Holdings had forwarded a referral for another major client. None of these clients had terminated our relationship. Someone was feeding false information to the partners while my actual clients remained satisfied and engaged. The training department's access logs showed one more entry scheduled for tomorrow night at 1:30 a.m. The partnership at our firm operated on trust built over decades of shared success. I'd joined as a junior associate 8 years ago, fresh from Delaware Law School with corporate law ambitions. Colton Blackstone had been my training director then, guiding me through complex merger protocols and client relationship management. He'd stepped in for me mid-cross when I froze in court during my 2nd year. The opposing counsel had challenged our client's financial disclosures, and I'd lost my composure completely. Colton appeared at the counsel table within minutes, smoothly redirecting the examination and salvaging the case. That intervention had saved my career and cemented my loyalty to him. Now, staring at the unauthorized access logs, that loyalty felt like a weapon turned against me. I spent the next morning reviewing every client interaction from the past 6 months. Morrison Industries had increased their retainer by 40% in September. Sterling's IPO work had generated over $200,000 in fees. Blackstone Holdings had referred 3 additional clients, each bringing substantial revenue to the firm. Yet, according to the partnership meeting minutes, these same clients had expressed dissatisfaction with my performance. The disconnect was impossible to reconcile through any legitimate explanation. I called Morrison's CEO directly at 2:15 p.m. "Elias, good to hear from you," he said immediately. "We've been meaning to schedule that follow-up meeting about the European expansion. Your team's work on the acquisition has been flawless." "Any concerns about our service level?" I asked carefully. "Concerns? Quite the opposite. We're recommending your firm to our subsidiary companies." "Why do you ask?" I deflected with scheduling talk and ended the call. Sterling's general counsel gave me similar feedback: complete satisfaction, ongoing projects, and future referrals planned. Though was clear, someone was fabricating client complaints and feeding false retention data to the partnership. The systematic nature of the deception suggested careful planning and intimate knowledge of our internal reporting systems. I needed to understand Colton's access patterns better. The training department maintained separate servers for educational materials and mock case files. Active client data should have been completely segregated from their systems. That afternoon, I visited the IT department on the 3rd floor. Daphne Blackstone, our systems administrator, had worked at the firm for 12 years. She knew every database, every access protocol, and every security measure we'd implemented. "I need to understand something about user permissions," I told her. "How would someone from training access active case files?" She frowned at her monitor. "They shouldn't be able to. Training staff have read-only access to archived cases and educational materials. Current client files require partner-level authorization or direct case assignment. What if someone had elevated privileges? Only partners and senior associates have that level. Even then, we log everything. Every file access, every document view, every database query gets recorded with timestamps and user credentials." I described the access patterns I'd discovered without mentioning Colton specifically. Daphne pulled up the authentication logs and studied them for several minutes. "These entries show valid credentials, but the access pattern is unusual," she said. 47-minute sessions suggest someone was systematically reviewing files rather than working on specific tasks. Most legitimate access lasts either a few minutes for quick reference or several hours for active work. Could someone use another person's credentials? Possible, but unlikely. We require password changes every 90 days, and the system logs IP addresses. If someone was using stolen credentials from a different location, we'd see geographic inconsistencies. The IP addresses in my logs all originated from the training department. Either Colton had legitimate access I didn't understand, or he'd found another way into the system. I spent the evening reviewing partnership agreements and internal policies. Training directors had broad access to educational materials and historical case studies, but current client files remained restricted. The policy manual was explicit about information barriers between active cases and training materials. At 11:30 p.m., I received an automated alert from the case management system. Someone was accessing the Morrison file again. I logged in remotely and watched the activity in real time. The user was downloading billing summaries, client communication logs, and case status reports. Each document stayed open for exactly 3 minutes before moving to the next file. The pattern suggested someone was copying information systematically rather than reviewing it for legitimate purposes. I captured screenshots of the access logs and documented the download activity. The session lasted 47 minutes, ending at 12:17 a.m. Whoever was doing this had established a routine. The next morning, I found an email from Colton in my inbox, sent at 7:45 a.m. "Elias, I need to discuss some client feedback we've received. Can you stop by my office this afternoon? We should address these concerns before they escalate to the partners." The timing felt deliberate. He'd accessed my files at midnight and was now scheduling a meeting about client feedback that I knew didn't exist. The manipulation was becoming more aggressive. I arrived at his office at 3 p.m. with printed copies of my client communications and billing records. Colton sat behind his mahogany desk, the same one where he'd mentored me through countless training sessions. "I've been reviewing your recent performance metrics," he began, opening a manila folder. "Several clients have expressed concerns about responsiveness and case management. Morrison Industries mentioned delays in document production. Sterling's team questioned some billing practices." I placed my printed emails on his desk. "These are direct communications from both clients. Morrison's CEO praised our work yesterday. Sterling's general counsel has no complaints about billing." Colton glanced at the papers without reading them. "Client communications don't always reflect their true concerns. Sometimes they express dissatisfaction through other channels." "What other channels?" "The partners receive feedback through various sources: board members, industry contacts, informal conversations. Not everything gets documented in formal complaints." His explanation sounded rehearsed. I'd heard him use similar language during training sessions about client relationship management. The difference was that those sessions had involved hypothetical scenarios, not fabricated accusations against real clients. "I'd like to speak with these clients directly," I said. "If there are concerns, I should address them immediately." "That might not be appropriate at this stage. The partners prefer to handle sensitive client issues through established protocols." The conversation continued for 20 minutes, with Colton deflecting every specific question and offering vague references to unnamed sources and unspecified concerns. He was skilled at the manipulation, using training techniques I recognized from our early sessions together. As I left his office, I realized the scope of what was happening. This wasn't just about accessing my files or misrepresenting client relationships. Colton was systematically undermining my position within the firm while maintaining the appearance of mentorship and support. The question remained, why target me specifically, and what did he gain from damaging my reputation with the partners? That evening, I discovered the answer in the partnership's annual review documents. The firm was considering promoting 2 senior associates to junior partner status. The decision would be made at next month's board meeting, based on client retention rates, revenue generation, and overall performance metrics. My name appeared on the candidate list, along with one other associate. If my client relationships appeared to be deteriorating, the promotion would go to the alternative candidate by default. I checked the other candidates' file access logs. Clean. No unauthorized entries, no suspicious activity, no fabricated client complaints. Colton wasn't just destroying my reputation. He was clearing the path for someone else's advancement. The betrayal was complete, calculated, and devastatingly effective. The confrontation required careful preparation. I couldn't approach Colton directly without concrete that would hold up under scrutiny. The partnership's decision-making process demanded documentation, not accusations. I spent the weekend compiling a comprehensive report, screenshots of the unauthorized access logs, time-stamped entries showing file modifications during my court appearances, and detailed analysis of the fabricated client complaints. The pattern was undeniable once presented systematically. Monday morning, I requested a meeting with managing partner Daphne Blackstone. Her assistant scheduled it for Tuesday afternoon, giving me additional time to refine my presentation. The meeting took place in the firm's main conference room. Daphne reviewed my documentation methodically, asking pointed questions about technical details and timeline verification. Her expression remained neutral throughout the presentation, but I noticed her taking detailed notes. "These are serious allegations," she said finally. "If accurate, they represent multiple violations of firm policy and professional ethics standards. I understand the gravity of the situation. That's why I've documented everything thoroughly before bringing it to your attention. I'll need to involve our ethics committee and potentially outside counsel. This type of internal investigation requires careful handling to protect both the firm and all parties involved." The investigation began immediately. Daphne assembled a 3-person committee, including herself, another senior partner, and an outside attorney specializing in legal ethics violations. They interviewed me extensively, reviewed all documentation, and began their own analysis of the firm's digital systems. Colton was placed on administrative leave pending the investigation's completion. The official explanation cited internal review procedures, but word spread quickly through the office. Associates and staff began asking questions about the sudden change in training schedules and Colton's absence from partner meetings. During the investigation, additional emerged. The IT department discovered that Colton had accessed files belonging to 3 other associates over the past 18 months. The pattern suggested a systematic approach to gathering information that could be used to influence partnership decisions and client relationships. More disturbing was the discovery of altered billing records. Colton had been adjusting time entries and expense reports to inflate his own performance metrics while subtly reducing the apparent productivity of potential competitors for advancement. The IRS Criminal Investigation Division became involved when the committee discovered of tax implications related to the altered billing records. Ethics Enforcement Director Kevin Brown was assigned to coordinate with the firm's investigation, ensuring that all regulatory requirements were met. Kevin's involvement added federal oversight to what had begun as an internal matter. His team conducted interviews with affected clients, reviewed financial records, and analyzed the scope of potential damages to both the firm and its clients. The Delaware State Bar was notified as required by professional responsibility rules. A formal complaint was filed, triggering their own disciplinary proceedings parallel to the criminal investigation. 3 weeks into the investigation, Colton requested a meeting with the Ethics Committee. His attorney was present, and they offered a full confession in exchange for cooperation with ongoing investigations. The details were worse than I had suspected. Colton had been manipulating partnership decisions for over 2 years, systematically undermining associates he viewed as threats to his own advancement within the firm's hierarchy. The client complaints were entirely fabricated, created using information gathered from unauthorized file access. His motivation was financial and professional. The training director position was intended as a stepping stone to partnership, but the firm's growth had stalled, limiting advancement opportunities. By eliminating competition among senior associates, he could position himself as the obvious choice for promotion when opportunities arose. The confession included details about how he had obtained access to secured files. As training director, he had administrative privileges that allowed him to override certain security protocols under the guise of preparing educational materials and case studies. The firm's response was swift and comprehensive. Colton was terminated immediately, with the partnership voting unanimously to pursue all available legal remedies. Criminal charges were filed by the state attorney's office, including fraud, computer crimes, and professional misconduct. The Delaware State Bar suspended his license pending the outcome of criminal proceedings. The disciplinary hearing was scheduled for the following month, with the expectation that permanent disbarment would result from the criminal conviction. Client notification was handled carefully to minimize damage to ongoing cases and relationships. The firm provided detailed explanations to affected clients, offered fee reductions where appropriate, and implemented new security protocols to prevent similar incidents. My own position within the firm was restored, with the partnership offering a formal apology and immediate consideration for the junior partner promotion that had been the target of Colton's manipulation. But the damage extended beyond individual careers. The firm's reputation suffered, requiring extensive efforts to rebuild client confidence and demonstrate the effectiveness of new oversight procedures. I worked with the Ethics Committee to develop improved security protocols and training programs designed to prevent similar incidents. The experience had revealed significant vulnerabilities in the firm's systems and procedures that needed immediate attention. Other associates who had been affected by Colton's manipulation came during the investigation. Their cases were reviewed individually, with appropriate remedial actions taken to address any damage to their careers or client relationships. The criminal trial proceeded quickly due to Colton's confession and the comprehensive documentation provided by the firm's investigation. He was sentenced to 18 months in federal prison and ordered to pay restitution to the firm and affected clients. The Delaware State Bar's disciplinary proceedings resulted in permanent disbarment, ensuring that he could never practice law again in any jurisdiction. 6 months after the initial discovery, the firm had implemented new security measures, revised its partnership evaluation procedures, and established ongoing monitoring systems to detect similar misconduct before it could cause significant damage. 12 months later, I stood in my new corner office overlooking the Brandywine River, watching morning light filter through the windows of Daphne Whitmore's boutique corporate practice. The nameplate on my desk read Senior Partner, a position I'd earned through merit rather than manipulation. The transition from the old firm had been smoother than expected. Several clients followed me, appreciating the transparency I demonstrated during the Colton Blackstone investigation. My caseload focused on corporate compliance and ethics consulting, helping other firms avoid the vulnerabilities that had nearly destroyed my career. The Delaware legal community is small. Word travels quickly about both scandals and redemption. My role in exposing the partnership manipulation had earned respect from colleagues who valued integrity over politics. Daphne had offered me the partnership after working together on a complex merger case. Her firm specialized in representing smaller corporations seeking ethical legal counsel without the overhead and politics of larger practices. The work felt different now. Each case carried the weight of lessons learned about trust, verification, and the importance of transparent systems. I developed a reputation for thorough documentation and clear communication with clients about billing, strategy, and expectations. My testimony at the State Bar's Ethics Reform Committee had contributed to new requirements for partnership evaluation, transparency, and digital audit trails. Other firms were implementing similar safeguards, reducing the likelihood that future associates would face the manipulation I'd experienced. The criminal case against Colton had concluded with his release after serving 14 months. He'd moved to another state, barred from practicing law anywhere. The restitution payments continued monthly, a reminder of consequences that extended far beyond professional embarrassment. I fight for reform in attorney mental health screening processes, recognizing that the pressure to succeed in competitive environments can drive good people toward destructive choices. The new practice allowed me to mentor younger attorneys, sharing hard-earned wisdom about navigating firm politics while maintaining ethical standards. Their questions reminded me how much I'd learned about resilience and the importance of allies who value truth over convenience. Evening walks along the riverfront had become routine, providing space to reflect on the journey from betrayal to redemption. The anger had faded, replaced by determination to build something better. Client relationships felt more authentic now, built on demonstrated reliability rather than inherited trust. The smaller firm environment allowed for closer attention to individual cases and more personal investment in client success. The partnership agreement I'd signed included provisions for transparent financial reporting and shared decision-making authority. No single person could manipulate the system without multiple safeguards triggering immediate review. My desk held a small framed photo from the Bar Association's Ethics Awards ceremony, recognizing my contribution to improving professional standards. The recognition mattered less than knowing the work had prevented others from experiencing similar betrayal. The silence in my office each evening felt different from the tense quiet that had marked those final months at the old firm. This was peaceful silence, earned through honest work and clear conscience. It was finally over, and the silence felt earned.